A lot of homeowners think the biggest risk with solar is whether the panels actually work. But honestly, one of the biggest risks is what happens before installation even begins. It's the sales pitch. Hi everyone, I'm Tim Coons, managing partner at Counxel legal firm. Today we're talking about the gap between what many homeowners are told during a solar sales presentation and what's actually written in the contract. Recurring issues in residential solar disputes, including verbal promises, financial confusion, and contract enforcement concerns. Because we're seeing more and more people say things like, that's not what they told me. And by the time they realize it, they've already signed. Now, to be clear, there are good solar companies out there. There are companies doing quality work, explaining terms correctly, and helping homeowners save money. But at the same time, there are also situations, rising situations now, where consumers feel pressured, rushed, or misled during the sales process. And it usually starts the same way. A salesperson shows up at the door, the conversation sounds exciting, lower electric bills, tax credits, the system will pay for itself, maybe even promises about generating excess energy or eliminating the utility bill altogether. The problem? A lot of those promises never make it into the contract. And legally, that matters because once disputes happen, the contract becomes the center of everything, not the conversation on the front porch. One of the biggest issues we see involves tax credits. Many homeowners are told they'll receive a large refund check from the government that will offset the cost of the system. But what many people don't realize is that the federal solar tax credit is generally non-refundable. The salespeople sometimes misrepresent the ITC as cash back, when in reality it only offsets qualifying tax liability. That's a huge difference, and if someone signs based on a misunderstanding like that, the financial reality can become very different very quickly. Another major issue is what I call multi-party confusion. The sales rep says one thing, the installer says another, and the financing company blames the solar company blames the contractor. Meanwhile, the homeowner is stuck in the middle trying to figure out who is actually responsible. This exact issue is a deflection strategy involving multiple parties shifting responsibilities between the sales rep, installer, solar company, and lender. And unfortunately, many contracts are designed to make disputes harder. Electronic signatures, mandatory arbitration clauses, restrictions on lawsuits, limited discovery rights, common contract red flags that increase consumer vulnerability. Most homeowners aren't expecting that when they sign paperwork at the kitchen table. And many don't fully review the agreement until there's already a problem. Now here's the important part. Just because someone signed a contract does not automatically mean every issue disappears. Arizona has passed specific solar consumer protection laws requiring disclosures, rescission rights, financing transparency, and warranty standards. The Arizona Solar Consumer Protection Act and its disclosure requirements for solar agreements. That means details matter. How the agreement was presented matters. What disclosures were made matters. And whether the contract actually complies with the law matters. If you're considering solar, slow down before signing. Ask questions. Get copies of everything. Review financing carefully and don't rely solely on verbal promises. Because the difference between a great solar investment and a solar nightmare is often hidden in the fine print. And if you already signed an agreement and feel like something isn't adding up, don't wait until the situation escalates. At Counxel, we help homeowners evaluate solar disputes, review contracts, and understand what options may still be available. Click the link in the description to learn more. Because when it comes to solar contracts, what you don't know can become very expensive.